Hey guys, thought you guys might find this interesting. There's a recent ruling from the North Carolina Supreme Court which held that nurses can be held legally liable for medical mistakes. This actually strikes down a 90-year-old precedent.
This video and podcast is brought to you by the Kulkarni Law Firm. Reach out to the Kulkarni Law Firm for advice on PRC review, MRC review, developing SOPs, training, audit compliance, and more. Reach out to Darshan at kulkarnilawfirm.com or call me at 302-252-6959.
People used to believe that since nurses worked under physicians for the most part, we couldn't hold nurses responsible for their actions in the same way. However, in those 90 years, there has been a change in the role of nurses, and we're talking, for example, in this case, about nurse anesthetists. And what you're finding is that courts are now, especially this court, for example, is taking the position that if you are going to be, if your practice is evolving, you should have some potential liability. Now, the important or interesting part of this is the idea that if you go down this path, the implication on clinical trials, for example, is profound, because what you now need to do is CRNAs may need to start holding the appropriate liability insurance. Are you as a physician going to still be responsible becomes another question. CRNA liability insurance will probably increase. All of these become things that you need to consider as you are A, negotiating clinical trial agreements, and B, considering what the ramifications are. So if you have questions about this, curious about what this means for your clinical research, feel free to reach out.
Hey guys, welcome to the Darshan Talks recording and podcast. On this podcast, we discuss life science, legal and regulatory issues, especially in the context of medical affairs, clinical research, and promotional compliance. If you like these videos and podcasts, please like, leave a comment, and subscribe. You know you want to.